Hi, I'm Bill McCall, the Political Director of Age United, and I'm here to talk to you a little bit about the Supreme Court case that is coming up around the Affordable Care Act. There's kind of a number of cases that started off. March 23rd was the two-year anniversary, actually, of the CARE Act, and over that 2 years, what's happened is that a number of cases were filed. Most of those cases were just ended up not being going anywhere. They were ended for lack of standing or for a number of different reasons. But in a lot of cases, it did actually go up to the 4th, 6th, and D.C. Circuit Courts, as well as the 11th Circuit Court. The 4th, 6th, and D.C. flat out said, hey, none of these cases really works for us yet. The 4th Circuit sounds like it might entertain a case in the future. But the 11th Circuit Court did say that there was a case here. They ruled in favor of the plaintiffs, and what's going to happen is that that case is now being appealed by the government to the Supreme Court. There are basically two issues that are really important, and the first is our state's going to be overwhelmed by the sheer size of the Medicaid expansion in the Affordable Care Act. And then secondly, the other issue is whether or not individuals should be required to pay for insurance as part of an individual mandate. Here we go. All right, so let's talk a little bit about the individual mandate. The individual mandate is one of the two really major issues, the constitutional issues, that the Supreme Court needs to decide. And basically, let me set this up for you a little bit. Right now, almost everybody is into a small pool of insurers. So here's a little swimming pool with waves on it. And you know, if you have an employer or a private employer, you might be in a small pool. And you might be eligible for Medicaid, which is actually a fairly good-sized pool, but it has requirements such as being below a certain part of the federal poverty line and also having a disability. What the Affordable Care Act tries to do is to drive down costs by creating a really much larger pool that everybody in the United States has to buy into. And what that does is it means that people with health conditions, people with chronic diseases, and young healthy people who really aren't showing any kind of health issues all get into the same pool, and that in theory will help to drive the costs down. Now the problem is, how do you make sure that people who are healthy and otherwise not that interested in insurance, they're young, they're going to live forever, how do we make sure that they're interested in purchasing insurance? And the answer is you have to create an individual mandate. What that says is that there's a requirement that you have to pay, every person in the most people in the United States will be subject to purchasing insurance, and you'll have to show it on your tax forms, or be eligible for Medicaid below 133% federal poverty level, and between 133 and 400% you'll be subsidized to do this, but you need to show that you've purchased insurance, or you'll end up having to face a penalty. The advantage, though, of this is that we can get a heck of a lot more people into the insurance pool than we already have, a lot more coverage, and hopefully that'll also help people to start to pick up diseases earlier, understand, and get the health care that they need. Age United is weighing in on this case in the form of an amicus brief, a friend of the court brief, that was created by Lambda Legal. We're really grateful to them, and obviously we would like to side on the side of getting more people into health care. So what I'd like to talk about now is the second of the issues that the Supreme Court will be deciding, and that is the issue of Medicaid expansion. So what is Medicaid other than an M&M-like object here on my chart? It's actually a program run by both the state and federal governments in partnership to provide health care for low-income people, and there's often a second requirement like disability to have to be able to access the program. It's voluntary for the states, but right now every single state participates. So what's the expansion? Well, right now most states have a smaller level of participation. What it's going to do is that all people under 65, under 133% of the federal poverty level, are going to be eligible for Medicaid, and the federal government is going to cover 100% of the program beginning when the expansion happens on January 1st, 2014, until it eventually lowers down to 90% in 2020. we're expecting about 16 million people to be covered by Medicaid. Now, what's the argument? The argument essentially by the states is that that 10%, when they eventually are going to have to pay it, is a really huge part of the income. And the real problem that they've got is, even though they're accepting 90% of this income from the federal government, they're saying, well, this is such a large program, we literally have no choice. We are being coerced into accepting Medicaid. On the other side, people are saying, look, you don't have to do it, it's a voluntary program. Under your definition of coercion, isn't Medicaid right now a program that that is not acceptable? And so the Supreme Court's going to have to jump in and solve that issue. We've signed up for with the Bazelon Center, an organization that works on mental health issues, on an amicus brief, and of course Age United is in favor of this expansion. And I'll just add that I think it's important for people to know that there is also a brief that's centered around HIV/AIDS that the National Minority AIDS Coalition Council has put out, and unfortunately Age United wasn't able to sign on to that one because we've already signed on to the other one. And I think that's the information you need. All right, so what are the issues that the Supreme Court will be deciding? And the first issue is this issue of the individual mandate. And then, very importantly for people living with HIV, Medicaid expansion, because a large number of people are going to be eligible for that. Third is this question of standing, and what that means is, are these issues ripe for decision? Since they haven't gone into effect yet, no one's actually experienced a problem, and therefore can this issue really be decided? And then finally, the question of severability, which is, if the Supreme Court decides that the individual mandate actually is unconstitutional, does that mean that the rest of the entire Affordable Care Act is also unconstitutional? All right, so the Supreme Court is going to have two major issues that they have to decide in this issue of the individual mandate. And the first is whether or not the individual mandate is a tax or whether it's a penalty. And basically what is going on with that issue is that the supporters of the Affordable Care Act are saying, look, it's going to be collected by the tax administration, it looks like a tax, it walks like a tax, therefore it is a tax. The opponents say, you know what? Even though they say it looks and walks like a tax, what's really happened is that throughout the Affordable Care Act, it's called a penalty, so therefore it's not a tax. And the reason this matters actually is that there is an act called the Anti-Injunction Tax Act, and basically if it is a tax, what it means is that people cannot sue until that tax goes into effect. There's a second issue, though, that I think is really interesting. And suppose, and it has to do with what's called the Commerce Clause. Congress was given in the Constitution the right to regulate interstate commerce. So here we have, say, Nevada and California. Actually, I guess I've got them reversed. So here's California, here's Nevada. We've got a person who's here in Nevada, and what we're saying is that their purchasing of health insurance actually affects everybody essentially throughout the United States, not just in California. The opponents, though, of this are saying, look, this guy is just sitting here in Nevada, he doesn't want to buy health care insurance, that is inactivity. The proponents say, no, that's not true at all. Everyone eventually participates in health care. Essentially what's happened is, if he is hit by a car, so he jumps over here, say, and gets run down by a speeding vehicle, that basically he's going to end up in the hospital. He's going to be uninsured, and essentially the rates increases for everyone. And it doesn't matter whether he's here in Nevada or in California. The very fact that he's alive is enough to cause the commerce to happen. And it's inescapable that he's a part of the market. So that's essentially what the arguments are, and that's what the Supreme Court will be looking at. So the Supreme Court has one major issue around Medicaid expansion that they're going to need to decide. And essentially that issue is whether or not the states are being coerced into accepting this Medicaid expansion. What the people who have sued have argued is that the expansion is actually so large and that the states are already so reliant on Medicaid that, in fact, they will have no choice but to accept this expansion. And the pro side, though, says, hey, look, this is a voluntary program. Congress is trying to get people coverage. They want them to move inside our Medicaid. Here's our Medicaid with our M&M block. And that the whole goal, frankly, is to move people into a place where they've got some kind of coverage. That this is a voluntary program for the states. That Congress has always reserved the right to amend the statute around Medicaid, on top of which expansion has happened in the past and there hasn't been a protest before. And then finally, the Affordable Care Act starts by paying the states 100%, and then eventually, yes, it does move down to 90%. The states will have to pick up 10% of the cost, but that's really a pretty minimal thing to cover 16 million people. So that's really the argument around the Medicaid expansion. So let's talk a little bit about the timeline. How is all this going to happen? As I said, the oral arguments are going to take place March 26th, 27th, and 28th. And then actually we're expecting a decision probably by the end of June, which is about when the Supreme Court's term ends. I actually called the Supreme Court to find out exactly when that was, and I know that they've got a date in mind, but they don't know that they're going to hit that date, so I won't do that other than to say I'm pretty sure that it's at the end of June. What do we expect to happen? You know, we've got 9 justices that sit on the Supreme Court. This is Justice Scalia, and we've got Justice Breyer, and all these folks who are tasked with making this decision. What is it that they're likely to say? Well, as I mentioned before, we do have the argument specifically around the individual mandate under the Commerce Clause. I actually think that the Commerce Clause law is fairly well settled, and even though there is this issue of inactivity, there have been a lot of cases where the court has decided, for example, that even activity taking place all just within one state is good under the Commerce Clause, and that there are other things that fairly well resemble it. So I would actually think that probably we're going to see a 5-4 decision on that one, and I think that they'll rule to uphold the law. I did mention also that the other really major issue that they're trying to decide is about this Medicaid expansion. I actually think that the Medicaid expansion is on even firmer ground. It's very clear that Medicaid has been something that has been decided for quite some time. And I really believe that if they were to invalidate it under this particular argument that's being made by the plaintiffs, that they essentially have the potential to invalidate the entire Medicaid program and almost any other law that requires state participation, such as higher education laws and things like that. So I would be really surprised to even see a 5-4 decision there. I suspect that one may very well come in at 9-0 or 7-4 or something like that. Excuse me, 7-2, because that's what adds up to 9. But so Age United's position, of course, is that we believe that this law is constitutional. We are trying desperately to get as many people into health care as possible. Expansion of Medicaid is one way to do that, and ensuring that everybody has insurance over the individual mandate, as well as other good things that we like in this law, including that insurance companies are not going to be allowed to use pre-existing conditions to exclude people from insurance. So overall, in our estimation, this is a pretty darn good law. There are room for improvement, and that's something that obviously could be worked on, but we are hoping to see the Supreme Court come in. I'll just say that we're expecting a decision in June, and I think it'll be very interesting to see what happens. There is some sense of urgency, partly because we've got the election coming up, and also it'll be really important, frankly, to get systems in place by 2014 when a lot of these major portions of the Affordable Care Act come online. So that's about it from me. I hope that this has been helpful to you, and I look forward to talking to you in the future. Take care. Bye.